Today we are here to discuss the report of the High-Level Committee on Center-State Relations, sponsored by the Tamil Nadu government. The report was prepared by a 3-member committee presided by retired Supreme Court Justice Julian Joseph. It's a massive document and covers 10 broad areas that concern states across the country. To discuss some sections of the report, we are privileged to have with us Mr. Arvind Datar, Senior Advocate Supreme Court and one of the leading constitutional lawyers in the country. In fact, he is in the course of completing the 3rd edition of his commentary on the Constitution. Thank you, Mr. Datar, for joining us. Before we start our discussion on some of the individual segments of the report, I'd like to ask you, the recommendations in this report are so vast, they're almost like calling for a constitutional convention. Do you think that India needs a convention, a new constitution after 70 years, a new major rethink after 70 years?
Yeah. Thank you for inviting me on your popular platform. To answer the question, I don't think we require a rethink on the Constitution. The Constitution is absolutely fine. Some of the recommendations made in the Julian Joseph Committee or the Interstate Relations Committee are quite useful, which can be thought of to be included in the Constitution. But this will just require a few amendments to few articles. There is no need of an overhaul of the Constitution at all. And some recommendations may not be practical also, but they have taken the trouble of going deep into the present positions and made some suggestions. But I think the suggestions with relation to governors and Article 360 are worth pondering and implementing it.
Let us now go to the first area of the 5 that we are going to discuss, the one to do with constitution amendments. I'll broadly set out the current position. As of March 2026, we had 106 amendments to the Constitution. That is almost 1.5 for every year of our existence. America is at 27. So we obviously seem to make it simpler. There are 3 kinds of constitutional amendments: a simple majority one, and one with a special majority, where 2/3 have to vote, and then a special majority requiring state ratification. Now, the report proposed a significant change in all these things. Why don't you elaborate and tell us about the changes and what you think the advantages of the changes are, and perhaps some of the disadvantages of the changes
are? I strongly recommend for acceptance the suggestion made by the committee to make it difficult to amend the Constitution to take away or abridge fundamental rights. In fact, in 1965, the Supreme Court flagged this paradox where you could take away fundamental rights by a majority, but if you want to amend another article involving some state subject, you require the ratification of all the states. So something so precious as fundamental rights did not require ratification. So this was flagged by Justice Hidayatullah, and he said that our fundamental rights, the playthings of the majority. That's the word Justice Hidayatullah used, playthings of the majority. So I think one recommendation which I've always thought necessary was fundamental rights should become capable of being changed only by a 3/4 majority, so that they are insulated from changes by a simple majority. Today, if a parliament out of 500 seats has 3/4 majority or more than 2/3 majority, they can change important fundamental rights. So that recommendation of the Joseph Committee or the Interstate, I think I'll call it the Union State Relations Committee, is worth including in the Constitution.
Questions like not only majority of 2/3 of the states, but states with 2/3 of the population, which is completely new. Is that sensible?
No, I don't think that is viable. Also, they have recommended adding a clause to include that basic structure cannot be amended. That's not necessary. It's already part of the judgment. And they have also recommended that a constitution bill must be introduced 3 months in advance and should be subject to public consultation. That's also is a good suggestion. But 2/3 of the whole state, etc., will be impractical, not necessary.
Also, if I could ask you about the basic structure, even if you wanted to put it, how would you define it? I think in 1964, Justice Potter Stewart said in America that, when I see pornography, I recognize it, but I can't define it in words. So is basic structure one of those things which you can see but not define? And if you can't define it, how would you put it in the constitution?
See, this is a oft-quoted criticism of basic structure that it's an undefined term, it is vague, and so on. But I think that criticism is not valid. It is by people who don't understand the basic principles of of constitutional law. In 1965, before Kesavan Bharati came, in the Sajjan Singh case, Justice Mudholkar said that, you see, by 1965, the constitution had been amended 17 times. So, as you put it, it was almost one amendment per year, and various rights had been taken away. So, Justice Mudholkar said it's time to press the pause button. How far can you go on amending the constitution? And he asked a very important question. Suppose in the constitution you take away the right to equality, you take away the right to life, you take away the right to free speech, then can you call what remains a constitution at all of a republican democracy? Can you think of a constitution of a republican democracy that doesn't have the right to free speech, right to life, and right to equality? Then what is left? So he said, where do you? So he ironically referred to a Pakistan Supreme Court judgment and said there are certain essential features of the constitution you can't touch. Then the question, what are these essential features? And Justice Mudholkar very nicely says, look to the preamble. What are the essential features? Liberty, equality, fraternity, social justice. These are the essential features of the Constitution. So if you take that away, equality, liberty, all parts of the basic structure. And now one more thing, Kesavan Bharati is now 53 years old. The Supreme Court has laid down norms for basic structure. And other thing is that it's only on 5 or 6 occasions that a constitutional amendment has been struck down on basic structure. So by and large, courts have supported the wisdom of the legislature, of parliament in amending the constitution. It's only on certain cases where they have said, no, you're going too far, and then they have struck it down. The last being the National Judicial Appointments Commission. The very flexibility of this term is its strength. Like there is no definition of due process in the American Constitution. But as years go by, we don't know what will be necessary 10 years down the line, 20 years down the line. So a concept which, as you mentioned, is easy to understand but difficult to define, its inability of definition may be its greatest strength. It can be molded to meet the necessities of generations.
One of the suggestions made in this segment of the report concerns amendments that run its course after 15 years and get run out. But the question is that amendment this important and useful is no longer available after 15 years. No, unless it's reenacted that period. There could be a very important amendment that is very useful that for political reasons cannot be reenacted. So we are then deprived of that amendment. Is that reasonable?
I don't think that is practical, because how do you identify those propositions which are required after 10 to 15 years? Which are the the suggestion is made that you make a list of provisions which require rethink every 10 years or every 15 years. Now take for example reservation. The first they said reservation should not last more than 10 years, but you have kept on continuing it indefinitely.
That they should cease
So
to have it.
I don't think this is a practical suggestion of making a schedule and saying that out of 375 articles, put 20 in some schedule which will be re-thought of every 10 years. I don't think it's necessary.
Let's move to another segment of the report, which is a bit of a hot potato, which is delimitation. We know what theoretically delimitation is supposed to do. We know your views on delimitation, and we know the report's views. So tell us, what is the overall suggestion in the report on how delimitation should go ahead? It's supposed to go ahead in the first election after 2026. That's the original constitutional amendment. What does this report suggest?
See, this, because of shortage of time, I can't go into detail, but this committee suggests 4 options.
But please do take a fair amount of time. This is a very important thing.
Yes. No, this
Please
committee
take some
suggests.
time because it's a very important thing. So please give your views.
See, I have spent quite a lot of time thinking about this delimitation issue, particularly because it's now likely to start in 2026. This year it is supposed to start. As you know, as you rightly put it, it has been frozen. The 1971 census has been frozen, and effectively under Article 81, 82, etc., the seats of Parliament are 550. They will be. See, there is a time. In fact, go to the Constituent Assembly. The mantra was 1 million electors for one seat in the Assembly. So for every 1 million, you have one representative. So if you go by that, then we could have 1,400 members in Parliament, 1 million per seat. Yeah. So that I don't think is possible. Secondly, see, you like Hugo said, you can't stop an idea whose time has come. There is also a flip side to this. There is also a time where this idea has to be buried once and for all. Now, this delimitation, at least in my personal view, because of the existing politics, because of the differences in population explosion, south versus north divide, as all of us know that if you impose delimitation, now everybody in the country knows it's going to impact the southern states very badly, and it's going to benefit the northern states. So virtually after some time, you don't need the southern states. The northern states can pass through any amendment without bothering about the southern state votes. That is not going to be acceptable. It may lead to serious social upheavals and so on. I personally feel it is time to permanently freeze 550 seats once and for all. Like in the US, you got the Senate has 50 members, so that's the end of it. There is no question of whether the population is 200 million or 400 million. You're going to have more number of seats. That's not going to happen. We just keep 550 seats permanently. One thing, and then you, even if there are a disproportionate vote, it's all right for two reasons. One, there are far more pressing problems which face the country now than getting into delimitation. You're going to have a huge social cost of getting into delimitation. Secondly, if you really want to increase seats, then as I suggested in my article, keep the same proportion. If Tamil Nadu has 40 seats out of 550, then you make it 700, make it 800, make it 1000. They will continue to have 40 to 50. The same pro rata proportion continues. That will at least not be a ground to complain. What I want to ask is, what is the purpose in having, if you're going to have 800 members, how are you going to subserve the constitutional requirements? Because ultimately, the role of the legislature is to make laws. Members of parliament to sit in parliamentary committees, deliberate on laws. How will 800 members going to improve the functioning of parliament if we are not going to refer bills to the parliamentary committees, if there's not going to be proper debates in parliament, if there's going to be this kind of disruption? I really don't know what is the purpose will be served by having 800 members or 900 members. Number one. Number two, what is the additional cost of keeping 800 members? Housing for the members, allowances for the members, with no benefit to the nation. That's a slightly cynical view. But at this point of time, increasing it to 800, will it make any difference to the major problems we are facing in terms of employment, in terms of economic growth, and so on and so forth? I think it's as you said, it's a hot potato. Better to keep this potato in cold storage. Just freeze it to 550 and be done with it. That's my personal view. Or if you increase it, then make it in proportion.
The report suggests that the distribution be frozen until 2126, or until the fertility rates of the states
TFR,
converge.
yes.
Now, the question is that, today, let me give you an example. Today, the population of the southern states is about 27 crore, and they have 129 seats. UP has a population of 24 crores and has 80 seats. If you look at the forecasted population in 2126, UP will have 66% more in terms of population than the South, because UP comes down slowly, but the South comes down much faster. And then still, the South will have more seats than UP. So my question is that, should one look at written about the report talks about the Rajya Sabha, 6 seats per state. Should the Rajya Sabha become more powerful like the Senate to remove this problem that we have of Lok Sabha being the dominant seat. If the Rajya Sabha was as dominant as the US Senate, then a 6 seat per state would much more resolve that problem than all this what you think you're doing for 100 years, holding up delimitation. Because today,
Yeah,
the
see,
US House,
Huh.
there are still states with 1 seat, and there are 2 senators. Because the senator, so that if you make that house more powerful, give it more financial powers, then could that resolve the problem in some way?
No, I don't think so, because you see, we can't adopt the American model. We have adopted the Westminster model, and the Rajya Sabha is not exactly like the House of Lords, but it's like the State of Elders. We had a bicameral legislation. The point I wanted to make was, if you're increasing the Lok Sabha seats, then proportionately you will increase Rajya Sabha as well. So the role of the Rajya Sabha is important, because in certain bills the Rajya Sabha's approval also is necessary, except in finance bills. It has to get the approval of the Rajya Sabha also. So I would suggest keep the same, the current ratio of what Lok Sabha is to Rajya Sabha. If you increase it, keep that increasing on a pro rata basis. So that will not give any grievance to the southern states, or not, and that they are losing at the cost of the northern states, and so on. You see, because what's happening is southern states, as it is, there's a serious tension because of the delimitation, because of language, because of other reasons. So it will only exacerbate the rift between the north and the south if you go down this delimitation path only on the basis of the number of people. And 2020, 21, 26 is 100 years away. Who knows at what time TFR will come in, what will happen? That's too long a period. We should, for the sake of certainty, because see, once you put that problem away, then you can focus on the other things which are bothering the nation. You see? I thought that we have now missed this bus of delimitation because of Indian population. And the four options, many of them, whichever option you take, I studied these options for this interview. These four options, every option is riddled with so many problems. If you take this option, then there are so many minus signs. So that becomes the issue. So I think ultimately the best thing is just keep the same thing going. If you're increasing seats, do on the same base. Let Tamil Nadu, Karnataka have the same proportion, then there's no problem. And other difficulty of delimitation is, what happens to assemblies? Are you going to increase all the number of MLAs in every state? You have to. What will be the huge cost? And is it worth it?
And I asked, there is a body called PRS legislator. It collects
Dr.
data
Madhavan
on
is
who
there.
speaks, in Parliament. I asked them to provide me data on the amount of speech of each MP. I think half the MPs don't speak at all.
Correct.
So nor do they participate. They vote, that's for sure. They are what is called lobby fodder. They just march in and press the button. So, actually, even a current size parliament, the participation is very limited thanks to the manner in which the speaker handles the opposition and the government. So a larger parliament won't make any difference. Just more seats, more money, and more waste of time. Let us now go to another hot potato, which we might still want to freeze. Language. The report says we must abandon the one nation, one language illusion. The three-language formula is a profound policy failure. English must be the permanent official language of the Union, the permanent link language of the Union, and entrench English permanently as the language for all constitutional courts. Now, that is what the report wants. Give me some pros and cons for that. As to how, we got to carry the rest of the country with us. So how do you think the rest of the country would react? What are the pros and cons of adapting this policy?
This question of, to put it problematic, to make Hindi is the national language and everybody should learn Hindi, etc. It is not going to happen without huge political upheavals. In fact, the entire Tamil Nadu politics is based on the anti-Hindi platform, and if you're going to push it down, it's going to lead even to violence and other serious consequences. We know what happened in the anti-Hindi riots which took place in the mid '60s. Now, as far as this question of pushing Hindi right through, it is again going to be a serious setback if you push it through for the nation as such, because it will lead to so many social problems, political problems. Now, one thing I've seen, because my wife works with an NGO which runs a lot of schools. There is a huge demand for English medium instruction. right? The schools where the regional languages is the thing, the admissions are declining. Many classrooms don't have enough number of students because everybody wants English, because that's the way for upward mobility, that's the way to get into jobs and so on and so forth. I think we must take a lesson from Lee Kuan Yew. When he first became prime minister, the first decision he made was English will be the language of Singapore. Though you had Chinese, Malay, and Tamils, he said if you have to come up in the world, we have to have English. So I think this question of each state downgrading English, and ironically, all the ministers shouldn't go to the best possible English medium schools, but they insist on Tamil medium and Hindi medium and Marathi medium. And ironically, like in Tamil Nadu, for the free midday meal scheme, only if you're studying in Tamil medium, you get the midday meal, which is ridiculous. Why not a poor boy studying English medium? So, to answer to your question on this language issue, I think there should be a national policy of promoting English with the regional language. And those who want to study Hindi will study. You see, when I was young, I mean, I was in Madras at that time. Many people joined Hindi Prachar Sabha because if you have to appear for the civil services exam, if you want to get into a central service, knowledge of Hindi is important. So today, if I feel Hindi is going to be necessary for me to get into the civil services or to get into a national thing, I will also automatically study Hindi. Don't make it compulsory. When you make it compulsory, there's a backlash. So let's just leave it to the local population. Let them read English and their local language, and Hindi can be an optional subject. That's the long-term solution, I think.
You know, let's look at the country as a whole. We only have the 2011 census so far. As for that census, if you look at the five southern states, around 15% have knowledge of English as the first, second, or third language. If you look at the five largest North Indian states, they are at 3.5% in terms of knowledge of English as first, second, or third language. You know, we do a fair amount of election work, so we go to rural areas. They say convent school, but there is no nun, and there is no teacher who knows any English. I mean, how do we get enough teachers of English language to get people in the north? I mean, it can't happen tomorrow. It's over 30, 40 years. Get them to a level of where they feel they can compete. Because now everything that matters nationally is done in English. So the question is, how do we organize that? What does the government do to provide help to people who go to schools? As you're absolutely right, most people now don't go to government schools, they go to private schools. Private schools that say they teach English. The quality of the teaching is terrible versus the South, where they've been teaching it for years and the quality is much better. So with that, with the North is a terrible disadvantage, how do we resolve that issue?
As you rightly put it, it is a serious problem which admits of no short-term solution. But as you put it, that's why now I was told the civil services exam you can now write it in your local language. You can write the civil services IAS exam. I'm told in Hindi also. I'm told, I don't know how far that's correct, but because you don't know English, you now make it convenient to do it in Hindi. And what happens to an officer who comes to southern states if he doesn't know English? I'll also tell you, in many of the northern states, in the district judiciary, they speak only the regional language. There's no knowledge of English at all. So if that district judge is going to become a high court judge, how is he going to deliver judgments? Rightly or wrongly, the language of the courts is English. Under the constitution, though the language is Hindi, under the Official Languages Act, English is to continue to be but English is not an official language under the schedule, you see, ironically. So I think that on a language issue, though this person recommends English and thing, I think we should make it, let the northern states start. The southern states had English. The northern states can catch up in 5 to 10 years, but English must be given as an option there. And in northern states, many of the people who can afford it, they go to a private school where English is taught. You see, a person pays sometimes a substantial part of his salary just in paying the school fees so the child can go to an English medium school. I'm not talking about quality of teaching, but at least the
But you know,
child
they
knows
are
English.
as far behind in English as the South is in Hindi. You know, they're really struggling
Yes.
in the North and East. So it will take quite a fair amount of time for them to catch up.
That also has a link with the higher per capita income of the southern states. I don't know if English is a correlation, but more upward mobility, more jobs in the IT sector, more jobs in various companies will go to the people from the southern states.
Require knowledge of English. Yeah. Well,
And I think as a national policy, we
let's
should
keep this
promote
hot
English.
potato and go now to the soft
Another hot. I think all are hot potatoes.
elections. The subject called elections. How do we use the report suggests that there should be a state election commission for each state. Then there should be teach how defectors should be treated. Give us your views on how defectors. State election commission. My views that just the way if the state election commission is appointed the way the central elections commission appointed, we'll have as much unfairness there as here. Actually, in the Supreme Court judgment, Justice Chandrachud suggested the manner in which the members of the election commission should be appointed. Of course, the government neglected those things. Actually, there is nobody from civil society. Like on the Information Commission, there are members of civil society. There's nobody of civil society. So how do we, do you think that allowing a state government to appoint the state election commission will give us any better results than the ones that we are getting now?
I think there's no better person to comment on election than yourself, because you've been covering elections for so many years and have been watching your TV programs for so many years. I feel that this suggestion of having separate state election commission is not a feasible solution at all, because I don't know if by putting state election commission you're going to have a more independent, robust body. I don't think so. It may make matters worse. So I think state election commission separately should not be there. The larger problem, which I feel, which the elections is the defection, is the issue of defections, and the issue of freebies. Freebies. See, because under the Representation of People Act, any gift or inducement is a bribe and is a ground to initiate an election. But if the promise is made by a party, it's not a bribe. So I think that the biggest vitiating factor at the election stage now are these freebies, which have completely vitiated elections. In many cases, they have been the game changer, unfortunately, with ruinous consequences to the state exchequer, state finances. I'm told in some states, between 40 to 48% of the entire money goes off in these distribution of freebies. So there is no money for capital expenditure for growth. That point, I lost the case in the Supreme Court in the case of Subramanian Balaji, where the Supreme Court asked the Election Commission that can you ban freebies? And ironically, the Election Commission said if all the parties agree, we'll ban freebies, which is like never going to happen. So I feel that the Election Commission or Parliament must first of all say that completely ban these financial incentives of free gas, free this. You can have basic food, because anyway you got food securities there. Why do you require any more freebies? Number one. Secondly, on anti-defection, the 10th schedule requires a major overhaul. You see, because no matter what you seem to do, the members of parliament or MLA seem to game the system. One they try to plug it by defection. Then Karnataka had the idea of mass resignation. See, so again you subvert the system. Then if out of 20 people, if 2/3 shift completely, then it is not a defection. So studying this problem, and the other worst thing is that the speaker is supposed to be an impartial person, but unfortunately, the two constitutional functions, speakers and governors, have really not performed their function as per the constitution. Speaker is not impartial. We know that. I've not seen a single case of a speaker being impartial at all. Maybe Malvankar was there in the beginning. I don't know now, but at that time. But that's one thing. I think that once you stand on, say, party X ticket, then no change should be permitted at all in your 5-year term. You resign, you stay out. No question of members of party X 2/3 getting together and joining party Y. That should be completely stopped. Secondly, how do you recognize the split within a party, like what happened in the issue Sena? That's another question which the constitution doesn't have an answer. So I think we'll have to amend the 10th schedule so that there is no question of changing from party X to party Y at all at any point of time. Not 2/3, not 3. Once you stand on party X ticket, for that 5-year term, if you want to change, you just resign and you cannot contest elections for the next remaining term of the that particular assembly. Then you stand whatever it is. That could be a possible feature. I don't know what are your views on whether that will really curb.
Let me place before you two examples that have taken place in the last 1 month. In Tamil Nadu, 5 or 6 ADMK MLAs resigned. Example 1. In Bengal, a vast majority of TMC members formed themselves into another party, and the speaker is recognized one of the members as the leader of the opposition. Now, how do you think these two examples, one, if 5 members just resigned, they didn't defect, they resigned. Well, how would you treat these two?
I think the 10th schedule should amend that once you have elected on, let's say, just to take the name on an AIDMK ticket, then you cannot change your party, you cannot resign. If you resign, you're no longer a member of the house, you're gone. That will be for a by-election, which the party can stand again. But you can't simply resign, Yeah. And like this question of forming a faction within
If
a
I
party.
resign, I can't find the same seat on a TVK ticket.
No, you can't. You can't in the by-election stand on the TV.
So you can't be represented at all.
Yes. Once you're elected
You
by
can
the
stand
people,
for by-election.
you can't stand for by-election at all because you have betrayed the trust of the people who voted you. They voted you on the AIDMK ticket. Now you have decided to resign. So that should be a deterrent. Otherwise, I will resign and I will
for
stand
5 years.
for the term of that 5 years. So I think you can add
So you're saying that 5 years I cannot stand again at all.
No.
There's
no.
another
So
thing that concerns me. As you know, MLAs are not allowed to hold office or profit. Now, if I were to resign and be thrown out as a MLA, the government could appoint me chairman of the State Textile Commission, the State Transport Commission, and all the other state commissions, and I can make as much money as I want to. I was making much less than I'm making more now. Is that okay? Or should they have nothing to do with anything with which the state has a control? To defect it for 5 years, you have to suffer a little.
Yes, I agree with your suggestion that there should be no indirect benefit that you resign. Okay, you can't be a member of the assembly, but I'll reward you with being the chairman of the State Transport Commission, or I'll reward you with so-called lucrative posts, as they call it, and you make your money there. Completely, they should be banned. So you take your election seriously. Once you stand on party X, and if you win, then you have to be with that party. If you resign, then for the rest till 2029 or till 2031, you can't stand for any election at all.
And do you think that office of profit business should also apply to sitting MLAs? That if I'm an MLA who's not a minister and you make me the chairman of the state transport body, because look at Maharashtra, I don't know what Tamil Nadu, every MLA is chairman of something or the other. So
Yes.
is that a legitimate office of profit?
In fact, there was some system of getting some parliamentary secretary. They tried to nominate them as part. That also Supreme Court struck it down. You can't indirectly do that because they wanted to get over the minister quota. You can't have more than 15% ministers. To get it over, they indirectly tried to do it. Mr. Sopariwala, the point is ultimately the statement of Dr. Ambedkar is so important on the last day. He said that there is no such thing as a good, however well the constitution you should draft, if the people who administer it are vile, are wicked, then nothing can be done by anybody. That's what the beautiful statement he said. He said, ultimately, it all depends on, you can have a bad constitution worked by good people, but if a good constitution is worked by bad people, look at what's happening in 10th schedule. From the Ayaram, Gayaram, every little point, it has not been successful. And look at the sad spectacle. You take 40 MLAs, you take them to some 5-star hotel, then you take away their cell phones. They'll not be accessed by anybody. It's a shameful thing, It's a shameful thing. Your own MLAs are taken away to some hotel so nobody can poach them. It's very sad state of affairs. Very sad state of affairs. And then you are talking of having more MLAs.
Let us now move to the last subject, yours favorite and my favorite, of governors. What does the report say about the governors, and what do you think is the right thing to do?
The governor issue has to be examined in the context of the presidential reference as well. What the one good suggestion which this committee has made is adding a 13th schedule in the constitution, which contains a list of instructions, or I would put it do's and don'ts of the governor. This is really paradoxical because governors are supposed to be people with gravitas, people with elder statesmen who don't need to be told what is to be done. I mean, you can tell a income tax officer or a civil servant, you can't do this, you can't. But at the level of the governor, the vice president, the president, it is expected that he has that much of responsibility, sense of nationalism that he doesn't need to be told. But unfortunately, the governors have been completely partisan, not just now for the last 30, 40 years. This question of governors has been very unfortunate. So one good thing will be to put it in on the 30th schedule. There's a certainty, number one, because you find that governors in states where the ruling party is there are different than from the governors in opposition states. Like say in Tamil Nadu, what happened? For 24 months, the bill was not even assented to. 12 bills were just kept pending without being assented to. And then that led to the controversy whether there can be a time limit. It went to a presidential reference, and they said no, there cannot be time limit. But they said if it is prolonged, unexplained, and another word they use, they can interfere. Isn't 24 months prolonged and unexplained? So what is wrong with putting a time limit of 3 months? And see, sir, if it's a simple bill, you can assent it in 48 hours or 24 hours. If it's a complicated bill, then you may want to examine its repugnancy, how far it clashes with central law, but it doesn't take more than 30 days to do that. 3 months is an outer limit, and the central government itself said, Ministry of Home Affairs said, 3 months should be the outer time limit. That's what the ministry said. So what is wrong with this time limit?
The report suggests that there should be people of integrity, etc., which is fair enough. But they also say that they should have just one 5-year term and nothing thereafter, which I think is a fairly good idea. That you're not looking forward to anything, nor have you been associated with the party earlier. But the main point I have is that Dr. Ambedkar said that he must do nothing in his discretion, nothing. So why do we have to go through this? The governor of Maharashtra, here we have a legislative council, and the chief minister can nominate, I think, 12 members. He sat on it for 3 years. And
Yes.
so the question is, I've followed up the question is that do we need governors? No, another country like India, which is a parliamentary democracy in states like us, is Germany. In Germany, the central government has a president, but the states have no governor. Why? What does the governor do? I mean, what do you think he does that we could miss out on if he wasn't there?
Actually, technically speaking, the governor has no role except.
The stars wouldn't be there, the soldiers would.
Yeah. You're right. I mean, that will require a
It costs
major
a lot of
cost.
money. I don't know whether,
Yeah, please go ahead.
there was a man called Mr. Biswanath Das, who was a member of the Constituent Assembly. He used to be Prime Minister of Orissa under the 1935 Act. He said that to Dr. Ambedkar that, these guys, you don't seem to have any work for them. They cost a lot of money. If you to pay them a salary, why have them? Should Dr. Ambedkar have listened to him?
Yes, maybe. But, sir, that will require a major constitutional change. And the report doesn't say abolish governor. They say you continue the governor system, but some checks and balances.
But even the checks in, there are so many things in the report that require constitutional amendment. The first
Yeah.
section is still full of amendments. Then, should there not be a debate at least with the governors when necessary? Because they don't seem to do anything useful as far as I can see.
No, actually, the point is who recommends president's rule then? Suppose you don't have a governor, who recommends president's rule? Then, say, for example, the power of pardon. Who decides the power of pardon? Thirdly, if a state law is going to conflict with the center, then if you don't have a governor, then the state assembly can pass any law. Then it has to be checked in the court. So the governor does have some important constitutional roles. I would not argue for a complete abolition of the governor's post because there are constitutional functions which he has to do. which and Article 200
Fine.
and 1 and so on. Yeah.
But when government falls under 356 or whatever it is, then there is central rule imposed. That rule actually is the rule of the central government. So is there any way in which, at least to ensure that when there is central government rule, that it doesn't become the rule of the central government versus that of the party that has lost the confidence of the House? Because currently the central government just takes over. So should there be some setup there where the current dispensation is not completely out of a new dispensation, which is having policies that are the centre's policy? So the purpose of central rule is not to impose central policy, it's to wait for a few months until a new government is elected.
See, but now that has been checked by the Bombay judgment. If you just indiscriminately impose president's rule, it's subject to judicial review and so on. But I would not agree with you that governor post should be abolished. Maybe because in my opinion, seriously put the constitutional architecture into jeopardy. See, because there is a rule, there is a president, then there is a governor, and there is a president and parliament, governor and assemblies. So they have a role to play. I can't think of a constitution without a governor. That will be too radical a change. I think instead of going down that path, we can have a situation where now that the governors don't know their constitutional obligation, put it in writing. A bill will be passed in 3 months. You'll do this, you'll do that. So just put it in writing as the committee said in the 13th schedule. That is a salutary provision and the system can continue. So, and the point is all over the country, the bill has to be done in 60 days. So whether it's Meghalaya or Tamil Nadu or Maharashtra, once the bill is given to the governor, in 60 days he takes a decision. We know that. Or you can put, if in 60 days it doesn't do anything, it's deemed to be passed. So that's...
So Dr. We have now discussed all the subjects there at the end. Would you like to sum up your views on the report? Overall, your 3-4 minutes sum up on the report, what you think. What you think is a good thing, bad thing?
One thing I must say is that a lot of study has gone into the report. They must be commended for the hard work they have done. Some very novel suggestions have come. And I think it is exactly this which is the part of our important democracy. The new ideas are thrown up. You debate them, discuss them. Wherever they are useful, you implement them. Where it's not practical, you don't do so. And talking union state, I think this is the third attempt. You had the Sarkaria Commission, then you had the Poonchi Commission, then you had this committee also. You also had a side committee of Venkatachalaya Committee on working of the Constitution. But this committee's report, I think, merits debate and discussion. Just because it is instituted by the Tamil Nadu government is not a ground to completely discard it. It may have been promoted by an opposition rule state, but it is headed by a Supreme Court judge. They have considered so many submissions, representations, and so on. And I think that it should be debated in Parliament, is my view, this particular report.
I think that is the end of the interview. Thank you very much, Mr. Datar, for joining us. It has been a great privilege, and we are delighted to have you. Thank you very much.
Thank you. It was lovely talking to you. All the best.